Hi, thanks for watching. Okay, so in this video, I'd like to talk about the recent order in the Sarah Boone case down in Orange County, Orlando, Florida. Okay, in this June 28th order, the court has addressed Patricia Cashman's motion to withdraw as counsel. This is very important because she's like the eighth attorney that's been appointed or has appeared as counsel of record for Sarah Boone. Okay, and as we go through the motion, we're going to see that every single attorney has had to basically withdraw because they can't get along with Sarah Boone. So it's a big problem. All right. Um, and I'll go through basically what the court says. But the first thing I'm going to note is that let's go back to the status conference, okay, where Sarah Boone was actually interrogated by the judge a little bit. And let's just take a look at her behavior and let's ask ourselves, okay, she may not be schizophrenic, she may not be psychotic, but ask yourself honestly, is this a sane person?
I'm very leery about having a fair trial at this point. There are a handful of other amendments that I have been researching and working on and trying to incorporate. To me, what I have written to you is obvious, and apparently from the correspondence that I get from the world, South Korea was the last place that I received correspondence, they obviously see the same thing. So I don't know what I'm doing wrong other than wanting to have a very successful outcome.
Okay, and I think part of the problem here is I think that Sarah Boone has a very apparently organized way of speaking. So her speaking is it sounds plausible, it sounds kind of organized, but when you really listen to what she's saying, she has no idea what she's talking about. Okay, and this is a problem. Somehow like our radar for mental illness is sort of set to like the extreme of psychosis or to some kind of schizophrenia or whatever. But when you have someone who gives off like sort of like an intelligent cadence, and they sort of present almost like the imitation of intelligent language, right? Then we just suddenly assume they're just completely, they're completely lucid and they're completely sane. And if you really think about what she's saying a lot of nothing. It's not a word salad. But it's very clear that she has no real orientation and no appreciation of the situation she's in.
I'm doing my best to let everyone know who I really am, as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope. Is to hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying.
One thing that occurs to me when I hear this is that maybe one of the mistakes we make with people who have personality disorders is we almost sort of like take them too seriously when they're talking, right? And sometimes it's better just to kind of make a little distance and just listen to what they're saying from a distance, not to take them too seriously. Because if you take it too seriously, you'll get upset, you'll get offended, okay? But the problem is that we kind of have to take that morality out of it, because I think clearly, if we're fair-minded, she is not a sane person. This is not the speaking. This is not the expression of a sane person. So if you just kind of take away that thing where we take it personally, because anybody can be offended by the way she talks, right? Because she's so self-important, she's so self-centered. But if you can just sort of take away that personal offense at what she's saying and just kind of listen, sort of neutrally, you can tell that there's something more going on. And it's not just that she's a jerk. It's not just that she's selfish. It is that she really is abnormal.
I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me and have a welcoming attitude, and things will probably change, and I will not get up and I walk out.
So my concern is that because she has an intelligent cadence, she has kind of an organized cadence, and she speaks sort of it's almost like a pseudo-intelligent language where she comes across as sort of sounding like she's a sane person. But if you really think about it, she's really not sane. I'm afraid maybe the court is taking her as a normal person and sort of doesn't understand somehow that what they're getting from her is really the communication of an insane person. I really think so. Because what she's saying is not just unreasonable. It's that I don't think she reflects really a sane appreciation of her situation. So when we look at the factual background of this order, we can see that Sarah has repeatedly been unable to get along with her attorneys. Okay, basically they use words like irreconcilable differences or that she has become adversarial. But because of the attorney-client privilege, basically the attorneys can't go into any detail, okay, as to like what are the dynamics like. And because they're attorneys and because they're not mental health professionals, they can't really mention anything, and it might even prejudice her case to actually mention maybe a suspicion of mental illness. So, right here, what I'm seeing is that there's problems in the way the legal system is structured. Okay. Because there's no way for, let's say, maybe a different judge to maybe rule on maybe a possible mental health issue that's kind of interfering with the attorney client privilege. And also, maybe we have to ask ourselves if maybe there shouldn't be a better organization of the appointed counsel system so that there could be maybe collaboration where attorneys could work in tandem with, let's say, counselors or mental health professionals. Okay. Because an attorney by himself may not even be able to assess whether there's mental illness present, right? And so, from the factual background of this motion, there's no mention of any possibility really that they may be dealing with a mental illness. So in the legal argument section, okay, the first item that the court addresses is the subject of forfeiture. Okay, this is when a criminal defendant can literally forfeit their Sixth Amendment right to counsel, okay, by essentially being hard to get along with, right? Okay, so basically, if you're sort of recalcitrant, if you're just almost engaging in misconduct that creates an issue of getting along with attorneys, and if it's over and over, basically the law can sort of imply that you have forfeited your right to counsel. Okay, and they go through extensive examples where people are just kind of hard to get along with, sort of the equivalent of sort of hanging up the phone on attorneys or slamming the door, kind of like what Sarah does, where she walks away when she doesn't get along, right? And so basically they try to package that as basically a situation of misconduct, okay, where you basically forfeit your right to counsel. All right, but what's notably missing from the court's analysis, and something that does appear when you read the actual case law and when you read like appellate opinions, is there usually is sort of a parallel analysis of whether the misbehavior is coming from, like, say, somebody who's not crazy or somebody who is crazy, right? And the same issue will tend to crop up in the second aspect of the court's argument here, where the court goes into the alternative, okay, that maybe if it isn't forfeiture, then maybe Sarah Boone actually has waived her right, implicitly waived her right through conduct, right? Through conduct, you can implicitly waive a constitutional right, and that she's essentially waived her right to counsel, okay, under the Sixth Amendment, right? The only problem is that, again, when appellate courts analyze these things, they tend to, take at face value, okay, there's been behavior that looks like a waiver, but then they go through the steps of saying, is there mental illness in the picture? Was this an intelligent and knowing waiver? Okay, just like if you present a will when someone dies and you say, hey, my grandfather left me $25,000, here's the will, the probate court's going to investigate, or at least there could be some investigation. Was the person signing the will of sound mind? Okay. Likewise, if you're going to actually be said to have waived a constitutional right, okay, there has to be some inquiry, at least at some level, as to whether it was an intelligent and knowing waiver. And it's interesting because in this court's analysis, they don't even talk about intelligent and knowing waiver. Okay. So that's a big deal. And I would think that, at some point on appeal, if the court thinks they're saving money now, the state's going to end up spending more money on the appeal. Okay. And so it's almost better just to get it right the first time. But I guess my concern here is that I just think the system isn't designed for people like Sarah, right? And so I don't have a good prediction for Sarah, really, because I think she's insane, but the question is whether she's insane enough. And above, you can see that I've clipped some case law that I just looked up very quickly on Westlaw, basically. And you can see that, the problem we have is that in our court system, when you're dealing with, like, say, waivers, or you're dealing with, the forfeiture of right to counsel, the standard for mental illness is set very high standard for mental illness. Okay. So just having a personality disorder, almost guaranteed not to count, right? Having, like, say, mild psychosis or mild schizophrenia probably doesn't count, right? Having a severe personality disorder combined with depression or something probably doesn't count, right? So you would have to have something like on the order of a severe, like real schizophrenia or psychosis combined with maybe some kind of brain injury or, super severe psychosis. Um, and I don't think an appellate court's going to cash her out as being insane, even though we can plainly see that she's insane. Although I do have a hunch that if Sarah were to submit or be submitted to a full psychiatric neurological evaluation, I have my doubts that she may have some organic brain injury from her alcoholism. Okay. So let's just leave that on the table. It may not get her all the way to full schizophrenia or full psychosis, but she may have some brain damage in addition to her personality disorder. So to me, that's a failure of the legal system. The legal system has established a tradition that we're going to set the bar so impossibly high for mental illness when it comes to waiving counsel, right? That basically it gives the courts room to basically do whatever they want to do, right? So this is a problem, I think, where the legal system, they create sort of a monopoly on the rules of the game. When a matter touches on mental illness, the legal system wants to take a whole monopoly on the issue, as opposed to maybe deferring to professionals and deferring to psychology to help define maybe a more realistic system for people who have mental illness. So, given the state of the law as it exists today, okay, the court's order, even though I don't like the way they reason through it, the court's order will probably pass appellate muster, okay, just because that's the state of the law today. But I am not really happy with the state of the law, okay, and I hope maybe in the future, probably not for Sarah Boone, but I would hope in the future we could see the law evolve a little bit, just a little bit. And I don't think the law is going to evolve by itself. Okay. I think the legal system is very stubborn. And I think the judicial system just doesn't move unless it really gets pressure. Okay. So what I would hope for in the future would be that maybe in some cities, okay, in some cities they could do like a pilot program, all right, where voluntarily they could do like an experimental program where the public defenders and let's say the system of appointed counsel, where they could have a system for more difficult cases, okay, where you have, like, say, extended handling for cases that have more legal difficulty or more difficulty with the client. Okay, so they could identify where you have difficulty with, like, say, a client, or, like, say, the complexity of the legal arguments involved in the case, right? So whenever a case is deemed to be difficult, you would have a shorter roster of specialist attorneys to get appointed, or maybe a special department in the public defenders where they would handle more complex cases, right? And then the second thing, if they could have a system as part of this experimental system where whenever you have, like, say, a difficult case, a case that's deemed to be complex because of the client, if you would have a mandatory collaboration with a mental health professional where you have like an experienced forensic psychologist who would collaborate with the attorney, okay, to assure effective representation and also help mediate, I think, some of the communications with the attorney. And that would be interesting just to see economically if the extra money spent on that program would actually cancel out the money that the state would lose in extended appeals for not handling correctly those kind of cases, right? So imagine it's just A or B, right? So you could either keep the present system, but you're going to have a ton of appeals, okay, and those cost money in the legal, and those cost the state money, right? So you could try, like, say, experimenting, like, say, in a couple of cities where you could have like extended handling and have, like, say, more collaboration with psychologists, and then see if maybe in those cities the money spent and invested on that program is saved because maybe the state doesn't have to, the appellate system doesn't have to get clogged with too many challenges. You know what I mean? So it's just a question of A or B. And it may be that in the end, it might be more economical to sort of front load these cases with a better handling, where you selectively identify like the most difficult clients and the most difficult cases. And in situations where you have a difficult client, you would definitely have more involvement with psychology, so that there could be like a better assessment of, I would say, the competency of defendants. Maybe they're not all the way legally insane, but they're insane enough that they're not getting effective representation, right? And I think in this case, the court made a safe decision based on the state of the law as it is today, but I don't think they're really honoring, I don't think, the true spirit of the Sixth Amendment. So, yeah, in my opinion, I think Sarah Boone is guilty, but I don't think she's going to get really fair treatment under the Sixth Amendment. even though the state of the law allows the decision that was made. I just don't think the state of the law really honors the Constitution in this aspect. So anyway, my opinion, and thanks for watching.